We are partners at Pruitt and Zabkowicz. Hey, come on and have a seat. We have an estate planning law firm, which basically we start with estate planning, and whatever needs to be done related to estate planning is what we do. And so today I wanted to discuss the basics of estate planning, and John will take over after that and talk about revocable trust and Title 19 planning. Covered so far?
Yeah, sounds good.
All right, sounds good. All right, the basics are will. Everyone should have a will at least, and it's important because you never know how things are going to pan out, who's going to die first, and what needs to be done. So it's good to have the basics to tell people who gets things after you die. And so wills can be very simple and say who's in charge of paying the bills and distributing the assets, but you can also have them for minor children on who's going to be the guardian to raise them and who's going to be the trustee for them. So wills work fine for people if you have basic beneficiaries, you have one or two beneficiaries. Usually you work that in tandem with beneficiary designations on your accounts. And I'm going to switch places.
Oh yeah.
So have a seat? Sure. So if you have a simple, straightforward situation, wills can be just fine. In Wisconsin, probate is triggered if you die with more than $50,000 of assets in your name with no beneficiary designation. So if you have a home that does not have a transfer on death deed and you die, your estate is going to probate. And so probate is something you want to try to avoid. And so we can talk about that in a little while. But the basics is you should at least have a will to tell people who gets what and who's in charge of paying the bills. All right. The second basic document is general and durable power of attorney. Who pays the bills and files your taxes if you are laid up, if you are incapacitated? Somebody's got to keep the heat on in your home. Somebody has to take care of your pet, be able to take the pet to the vet. Handle your digital property, anything you could possibly think of financially, that's what we want in the general and durable power of attorney. We have the option to make them springing, meaning two doctors have to indicate you're incapacitated before anybody can touch your assets, which is what most people have. So it doesn't take much. If you are truly laid up, doctors will declare that you're incapacitated, at least temporarily, so that your power of attorney can get access to your finances. Otherwise, people get to a certain age and they say, well, I'm not incapacitated and I have my capacity, but I don't want to go to the bank anymore. I want my son or daughter to start taking over. At that point, we can make them active. And so they just sign an active power of attorney. The person they choose to be their power of attorney now has access to all their financial assets and can invest that for them, pay their bills, handle their checkbook, and all that type of thing. So that's the second basic document. It has, when I first started as an attorney, they were half a page long. It pretty much just said, this person has all the financial capabilities for me, they can make all my decisions. And that's, what more would you want to say? And the banks honored that. Now the banks, the insurance companies, the title companies want specifics. And so over the years we had to add more and more to those documents, and it became such a situation where it's 11 pages long now. And it also provides for Title 19 planning in them. It's really important that you have the updated general and durable to allow movement of funds to protect some of your assets if you were trying to qualify for Title 19, and that's something John's going to talk about later on. Another basic document is a healthcare power of attorney. A lot of people have done these basic documents, the general and durable and the healthcare power of attorney, a long time ago. They've been updated since you've probably done them. The most recent update allows for not only admission to a nursing home or a CBRF, a community-based residential facility. It allows for the withdrawal of a feeding tube, also the do not resuscitate order, the basic decisions your power of attorney can make for you. Again, if you are incapacitated, the healthcare power of attorney kicks in. But it also allows for anatomical gifting, organs and parts and things like that. So you can specify whether you want that, whether you want to donate your body for anatomical study. Those are all in the new power of attorney documents, and they should be updated. Those are the 3 basic documents. There's one fourth one that I'm going to add to the list called an authorization for final disposition. It's a document that aids in your situation after you die. So who's going to take care of things with the funeral home, with the church, or whatever your situation is. You can specify what religious observances you want, if any. You can indicate if you want to be cremated or buried. A lot of people have funeral trusts already that they've taken care of with the funeral homes, which we highly recommend, so that a lot of times you can lock in prices ahead of time and make the major decisions ahead of time. And John will talk about that, the importance of that also.
Very important.
But we see the good, the bad, and the ugly after somebody dies. Our clients come to us and we try to do the best we can with paperwork to make their situation palatable for their beneficiaries and loved ones afterwards. We see the people coming in our office that didn't do that, and they're fighting and they're arguing over the size of the tombstone. We've seen some crazy things. So just having the basic documents in place really clears it up. You can indicate who's in charge. Someone can walk with a piece of paper to the funeral home and say, I'm so-and-so, here's my documentation, and this is what we're going to do. And they're in charge of doing it. So it eliminates a lot of issues and problems for families. And that's what we really want to do. We do this, of course, we're attorneys. We do this for a living. However, the reason we do it is to provide education to people and to help people. We're here to help people. We don't sue people. We send people away to another law firm for that. But we are here to help you, to help other people. We have free review of documents. We think it's really important that people understand if they have up-to-date documents.
Very important.
Yeah.
What we try to do is we try to eliminate confusion, and we want to make things as straightforward for you and your beneficiaries during your lifetime and upon your death, so there's really no confusion. As Jim mentioned before, the will is the basic estate plan. Everyone should have one. That's the basic. If you have a proper will and you have coincided that and did beneficiaries and all our assets, there's a good chance you don't need probate. And again, probate is a process. It averages about a year to year and a half. That's the process where a personal representative is appointed through your will. You name that person, they liquidate the assets, they have to pay all the debts. Creditors have 100 days to file a claim in your estate. All those debts must be paid. And once all the debts are paid, we can distribute everything to the beneficiaries. Again, you try and avoid probate, if possible, with putting beneficiaries on your assets, but you want to make sure those beneficiaries coincide with the will. So if you have 3 children, you want everything to go to the 3 children equally, you say that in your will, you could execute a payable on death in all your accounts. Go to your checking, go to your savings, put beneficiaries on your IRAs, your retirement accounts, or your life insurance policies, and then upon your death, those companies will pay your beneficiaries outright. And what happens is we then submit your will to the Racine County Register and Probate and say, so-and-so died this date. There is no need for a probate because all their assets have beneficiaries on it.
Would they take your word for it?
Well, I hope so.
They don't want our business. So.
Yeah, they don't want probate as much as possible. So what happens is all the assets that have beneficiaries, those get paid out to the beneficiaries right away. There's no need for any administration or any middleman like the probate is. You want to avoid that. Opposite of will, and the more advanced is become more commonplace, are called revocable trust. A revocable trust is kind of like a will. It's the vehicle that you use to designate who's going to take care of your assets when you pass away, who's going to be in charge, and who's going to distribute those assets to the beneficiaries. The benefits of a will of a trust is that you can control more from the grave, meaning you could have assets for your great grandkids in there and say upon their death they get this. You can have spendthrift provisions in these trusts, meaning that creditors cannot come after your beneficiaries if these assets are held in trust. You can have multiple beneficiaries, so you can say 3% to this person, 5% to this person, 10% over here, 5% to charity. The trust is a very, 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 very popular document for making beneficiaries, and as many beneficiaries you want for your estate plan. You want anything?
It's more creative. It's a creative vehicle that you can do more with. And it's interesting now as time has progressed. When I first started doing revocable trust, they did all these things that John's talking about. Now there's a new ability to leave money to an adult beneficiary. So when we first started, there's an advantage to have trust when you have little children, to hold it longer for them. But there's also now an advantage for the adult heirs. And
yeah, so if you have spendthrift children, or children that cannot handle money, you can just keep those assets in trust for them for as long as you desire. I've had trusts go throughout the lifetime of children and say, we appoint the trustee to take over. Most of the times it's a family member. Sometimes people do use banks, and that's commonplace too. The problem with the banks is not a problem, it's just they will charge you for the administration fees of being a trustee. But what happens is then they hold the money for your beneficiaries, and they won't give them to him or her until a certain age. And again, that's the flexibility of a trust. A trust is a living document as well too. So when you create a trust, you're putting your assets in there. You're in charge of the trust. You're the grantors, meaning you funded the trust. You're also the trustees, meaning you're in charge of the trust. So you can take assets in, take assets out, put assets in, put assets out. It's very popular for clients with a lot of properties or a lot of assets, because then the trust becomes the vehicle that transfers everything upon your passing. Also, like I said, the trust, there's no need for a probate. There's no court notifications. There's no court inventory filing fees you have to pay. There's nothing. So again, if you have a lot of money, you can save. An inventory filing fee for a probate is 0.2% of the value of the probate. So meaning when you pass away, you're going to owe the city of Racine or city, wherever you pass away in, $300 to, at the minimum, $300 to a couple $1,000. So again, the more assets you have, you're going to pay that automatically to the county. If you have a trust, you don't have to do that. There's no trust filing fee. We still notify creditors with a trust, and what happens is we still publish in the Journal Times or in Kenosha Freeman, is that what it is?
Kenosha News.
Kenosha News. And like I said, we still publish there, and that gives creditors that time frame to file a claim in your trust. What happens is the trustee, who's ever in charge, pays those debts and then distributes everything to the beneficiaries. Okay. Again, the trust is much more flexible. It's a much broader document. It allows for you to have more control from your grave.
There's also a spillover trust called a self-directed trust. When you leave assets to a beneficiary, they receive it instead of just getting a cashier's check if they're over 25, if that's your magic age. They'll get it, but it'll roll over into a self-directed trust, irrevocable trust, that they are the beneficiary of their own trust. They can still spend all the money, but while it's sitting in the name of that trust, it's protected from creditors and divorcing spouses.
And that's very important, because
Parents really love that.
Yeah, when beneficiaries receive money and it actually hits their hands, it's theirs. It's theirs. So unless they keep it in an individual account, again, spouses can get after it. But if they liquidate it from that trust, creditors can get after that. If you keep assets in trust for beneficiaries way upon your death and they never touch it, creditors can't get after that. So again, it's a very popular tool to have that trust. As I mentioned, so the trust, when you create, is revocable. When you pass away, it becomes irrevocable, meaning the terms of the trust cannot be changed. Okay, it's very, very difficult to do that, and that makes it, again, so creditors can't come after these assets. Beneficiaries can't, or where the trustee says, "Well, I'm the better brother. I get more than my other brother." They can't do that. So that's what irrevocable means. You can't change it. You can also create irrevocable trusts during your lifetime, and I do this a lot for clients that want to protect assets from potential Medicaid or for family generations. And what these irrevocable trusts are is when you create an irrevocable trust, you're making a gift to that trust. So you're getting it out of your name. All right, so for family cottage up north, for assets that you know you're never going to need, you put it into this irrevocable trust, and after 5 years, it's protected from Medicaid. If you need, nursing home, anything like that, they can't touch these assets. All right, so again, for family cottages, it's very, very important to this irrevocable trust. What we do then, like I said, you're giving up control, you're giving up ownership. So that's the one downside to that irrevocable trust that you created right away, because again, it's technically out of your name. even though it's still in your name, but it's out of your name.
Just a side note, for family cottages also, it's becoming more and more popular to do family LLCs, limited liability companies. You transfer the ownership of the cottage into this LLC that you've created, you make up a name, you know, the Pruitt Family Cottage Trust, whatever it is, and then we create rules on visitation for all the different family members, and because you have rules and what happens if someone wants to be in or out, it provides for multi-generation use for these family cabins.
And that is an alternative to the trust. And like I said, one of the benefits of that is that you can divide up shares right away. You could say this, you know, the son gets a 1/3 share. He's also the managing share of the family cottage. So if someone wants to be bought out, because again, a lot of times with these family cottages, you have 7 beneficiaries that now own the house. There's a lot of fighting that happens with 7 beneficiaries, so it becomes tough to buy people out or to have succession plans for that. So that this LLC has become very popular too. With regards to this irrevocable trust, it goes to my thing about Medicaid and for nursing homes. Again, nursing homes are great. Assisted living and nursing homes, they provide great value. They take care of people in their elder stages of life. They're also very expensive.
And that's where you go typically for rehab purposes.
Yeah, they're also very expensive. And the average assisted living facility here is like $3,000 to $5,000 in Racine. Memory care units around $6,000 to $8,000 a month, and then a full skilled nursing you're paying $9,000 to $12,000 a month. So you can spend through assets very quickly. All right, with the financial power of attorney that most attorneys create, we allow for language in there to have your agent protect assets if necessary. And how that works is for single persons, the general rule is we can protect around half of the estate, around 50% of the estate. For married couples, we can protect everything. And how that works is for single persons, if someone needs care, hopefully the power of attorney, the son or daughter sees the power of attorney and says, my mom wanted to protect assets, and that language has to be in there. What happens is they would meet with an elder law attorney and they would say, yes, my mom has a right here that she wants to keep as many assets as possible in her estate. What we do is we make a gift of X amount of dollars. It's usually around half of the estate. The remaining money is we put in what's called a Medicaid annuity. And this Medicaid annuity pays for this gift penalty period, or the penalty period that came from this gift. So if you gave a gift of $200,000 to the kids within 5 years of needing care, it's around 22 months of penalty period. This Medicaid annuity is set up for that 22-month penalty period to pay for that penalty, to pay for that period that's from the gift. After that 22 months is over, the monies are protected 100%, and that mom can get on benefits then. So again, it's a really good thing that we have in Wisconsin, where we can still use the rules for Medicaid protection. For married couples, we can protect everything. And for married couples, it's different because what they have is called a community spousal asset share. They want to make sure that the community spouse, the one that's living at home, is not kicked out of the home. They also want to have that community spouse keep a certain amount of assets, and the numbers are between $50,000 of assets and $139,000 of assets. The certain assets are exempt. One car is exempt. Any prepaid funerals are exempt. That's why a prepaid funeral is so important. Please, guys, if you can take one thing today, get a prepaid funeral. That is so important for Medicaid purposes. Not only, as Jim mentioned before, does it eliminate any confusion for your beneficiaries or your children when you pass away or your spouse, it also is exempt from Medicaid. That's, like I said, that's my number one thing I tell clients to do when they meet with you. If you don't have a prepaid funeral, go get it. Just please, go get it. Any place in Racine, Kenosha offers it. If they know what they're doing, they'll take care of you. But again, that's exempt from Medicaid. So one car, any prepaid funerals are exempt. The community spouses, retirement accounts are exempt. IRAs or retirement, anything they have in retirement, annuities are exempt, right? And the house is exempt. Everything else is countable. And Medicaid looks at those assets and say, well, you have $300,000 of assets, you have to get below $139,000. That's how they do it. So what happens is, if we want to get on benefits right away, we can create that same Medicaid annuity in an amount of like $170,000, and that will just pay the healthy spouse. And then the institutionalized spouse will get on benefits right away. So long story short, for married couples, we can protect everything. For single persons, the general rule is about half. That only comes into play with the power of attorney. Again, because if it's not in the document and you are incapacitated, then we can't do anything. I mean, if you're incapacitated, we can't do anything. Also, as before with the powers of attorney, if you have them in place, there's no need for guardianship. Guardianship is a cumbersome process through the court system that if you become incapacitated and you don't have any financial power of attorney or healthcare power of attorney, someone needs to be appointed by the courts to look over your welfare, to look over your well-being. It's an expensive process. It's an annual process, meaning there's an annual report to the court that you have to do. There's an annual accounting that you have to do. And again, the worst part about it is that you cannot protect any assets if you need care. So again, the powers of attorney for finances and healthcare are so important because again, you're giving literally direction to your beneficiaries or to your loved ones to say, hey, here's what happens if I need care. This is what I want you to do. I want you to protect as many assets as possible. So again, the power of attorney is.
One thing, some people have living wills. Confusing terms here. Living wills or physicians orders. What is it called?
Yeah.
Directives. Anyways, advanced directives. And so we recommend just having a healthcare power of attorney instead of. We don't want it to be in sync with a living will because some of the powers overlap. And the healthcare power of attorney attempts to give all of your decision making to the person you want to have that decision making, your spouse or your son or your daughter or whoever you trust with your healthcare decisions, right down to whether or not you should have a feeding tube or do not resuscitate order given. Sometimes the living wills, if you look at the language and the provisions, it'll give powers to other people, including physicians or staff, to make decisions on your behalf. So it is not necessarily a preferred document. The preferred document is the healthcare power of attorney.
Mm-hmm. Sure. And again, that financial power of attorney, which Jim mentioned before, I think that's the most important document that you can have. Because again, if you have a good one, you can alleviate the need for guardianship of the estate. You can protect assets if you need care. And with the financial power of attorney, again, you should have someone you trust, but the powers that they have can really make everything possible to do any type of plan that you need later on. If you want to create a trust that needs to be done on your benefit, that financial power of attorney can do that if you don't have one in place already. Again, if you want to protect assets, if you need nursing home care, they can do that. If you want to start making gifts, that financial power of attorney is in there, says, I authorize my financial power of attorney to make gifts out of my estate. Again, those are things that can't be done if you don't have that in place, because again, the guardianship won't allow that, and that's one of the most important things.
And we can make them springing or active. So springing indicates that 2 doctors have to indicate you're incapacitated before anybody can act on your behalf. Or we get people wandering in our office in their 90s and they're like, I don't want to do this anymore. And so then we make it active so they can allow their power of attorney to take over. And I think that's pretty important right now. And you can make your trustee active also if you have a trust.
Yeah.
The errors, we didn't talk about what people don't do correctly. We get all kinds of situations coming in and they like to, I don't know if it's the banks that are giving this advice, but people like to put their children on their accounts. So even though they might have 5 children who are going to receive everything, they make Susie co-owner of the account because it's easier. She can just write checks. It's easy, all right. It's easy, all right. But then you've exposed your asset. Well, it could be all your accounts if you put Susie's name on. You're exposing your asset to her divorce, her bankruptcy, her personal injury accident, and you're trusting that one person will carry out your wishes verbally.
If you pass away and that goes to Susie, it's Susie's. Susie can do whatever she wants with it. Mm-hmm. I've seen that. Yes, sir.
Yeah.
Every individual has got a little different problem, but how do you charge? Do you charge by the hour for the documents that have to be made or anything in that? Or
I used to. When I first broke in as an attorney, I worked for several places that every time, I always like to say, every time you drop a paper clip, they were charging people for your services. So that went against my grain. I didn't like to do that. So I developed a flat fee system and brought John in on that, and we feel very strongly that when people come to us for the free consultation, we discuss what we think they need. We give them a price quote printed on paper. That's the quote. Occasionally if somebody comes in and says, oh, I've got 2 more deeds, well, we're gonna charge them more for the deeds that need to be transferred. But we have a flat fee system for almost everything. We can't have a flat fee system for the Medicaid planning and the probates that we do, because we just don't know how long that's gonna take. It's different in every case.
Thank you.
Yeah.
But our general estate planning is flat fee, and again, before that I was only hourly, but some trusts they could be quite cumbersome, and you get a lot of pretty expensive trusts, and again, coming from Milwaukee, they're much more expensive than Racine, but the flat fee is what we do charge for estate planning, and I think that works well. So,
What you've been talking about, a lot of that it was so much that I lost 80% of it. If you guys had some kind of a DVD or a CD, and said what you had, and then if we were interested in going with you, we can understand. Now, like my wife isn't here today, she wasn't able to. To try to explain this to her is gonna be impossible. Because I'm just hanging on to a few things that you're saying.
2 things.
Can you come out with some kind of a CD so we can listen and understand what you're talking about? So when we go in, we know at least some things to be looking forward to.
Well, the good news, this is live streamed and it's recorded and it's gonna go on our website. So that's the plan anyways.
Yeah.
So you could go to our website, click on a link, and you'll see the whole presentation.
Or you will.
That's the plan. I told Journal Times indicated that we could do that. So.
Well, we don't know your website or anything like that.
Yeah, well, we'll give you a card.
yeah, we'll give you a
Or
card.
you give me a
Yeah.
Yeah, you know, because this is,
Yeah, and we do have the free consultations. You can come in and we can discuss your situation personally with
Right.
you. Yeah.
okay. Now I've got, of course, Medicare, and then I have very good health insurance, very good. Now, if a person goes into a nursing home or something and needs a lot, does your health insurance cover any of that?
Medicare covers the first 20 days. Any hospital stays covered, and up to 20 days of rehab is 100% covered. They then cover a percentage up to the first 100 days if you're showing improvement. If you're not showing improvement, and you have to go to an assisted living facility, memory care, or a full skilled nursing home, insurance does not cover that unless you have long-term care insurance. Long-term care insurance was great in the 90s and the 80s. If you bought it, awesome. If you did, if you bought it, it's so expensive right now, a lot of times it's not worth it. So what happens is you would have to pay privately for your stay at the facility, whether it's assisted living, memory care, or nursing home. You'd have to pay privately. Your insurance would not cover that. They only cover the rehab part or until you're getting better, and that's 100 days at the max. So again, you have to pay privately. And that's where, if you cannot pay privately or if you want to protect some assets, that's where you hopefully contact one of us and we can help the process of protecting assets. Because Medicaid is the state of Wisconsin's and the federally funded program that covers those long-term care needs.
Long time ago, I used to have people come in and they wanted to transfer assets ahead of time to avoid what was a 3-year look back then. And we had this paper chase going back and forth, and we move assets around. But we don't do that anymore.
I tell clients,
we follow John's.
And I tell clients to keep as many assets in your name as possible. Unless you're a multi-millionaire, keep as many assets seriously. Because what happens is these facilities, especially around southeastern Wisconsin, want you to pay privately for a certain amount of time, and they do, and that's part of their business plan. That's how they do it. So what happens is if you don't have any assets and you gifted everything out of your name already to your kids, well then you can't get in there, and that becomes a problem. So what happens is my advice to clients is we don't do any planning unless you have a family cottage or anything like that, or you want a second property, or you have multi-millions of dollars you want to keep. We don't do any planning until there's actually is necessary, until there's actually time to do planning. So again, we, like I said, back in the day, you used to give assets out of your name, you used to create irrevocable trust, put your main house in there. Now, I strongly advise against that. And like I said, just because these facilities around, southeast, all around Wisconsin, they want a private pay requirement, and they want you to have a certain amount of money in your name just to get in there. And if you don't have that money, they won't. You have to go looking for another place.
I have a friend that ended up going into a nursing home on the end of 3 Mile Road. And he, every year I have a program where he gives $50 donation. It's a citywide program that I have. And he cried. He says, I can't help you. I can't give you $50 because they took my home. His wife had passed away earlier. They took his home, all of his assets. So he didn't have a penny to his name in a nursing home because that money is going to be used like $125,000 a year. We'll wipe them out.
It's very expensive, you're correct. So.
And it's terrible. The guy couldn't even have $50 to give to this program that I have.
Yeah, and that's why the powers of attorney that you have to have those set up, because again, if you have a power of attorney set up, you can designate someone to say, hey, I want to protect as many assets as possible if I do need care down the road. And you have to have that advanced planning done, because if you don't, and you don't know, then again, you'll be in the same situation as your friend.
Yeah. Any other questions?
Yeah, I have.
Yeah.
You went through a program today, and you listed all the things that you suggest to do. So, is there what he was asking for? What you're going to give us here, but you could have had an outline, and you could have actually checked off the different types that we think that would be of interest to us.
Again, we offer free consultation, so we don't charge to come on in and discuss what benefits you the most. We just give a general overview today, but again, every situation is different. I mean, my mom just has a basic will, which is me and my brother. So she has just that. She didn't need a revocable trust. My wife and I have a revocable trust because I have 2 girls that don't sleep at night. So I have a 5 and 3-year-old, so I'm extremely tired. But again, every situation is different, and we offer free consultation, so we can tailor it to what you need specifically.
I mean, we have estate planning packages for a will package. We have a trust package. You come in, it'll show you all the documents included in there. We'll explain what they are. Some people just come in, like we get people moving here from another state, and they say, take a look at my will, tell me if I need a new will in Wisconsin. Well, we're not the attorneys who say, oh yeah, that this will from Arkansas is no good. We will look at the will, and if it complies with Wisconsin law, we'll say it's a valid will in Wisconsin as long as it says what you want. So a lot of people are shocked when we tell them we don't need to draft a new will. But the powers of attorney might be a different story. Right. So we just look at everybody individually and go through it specifically, exactly, curtail it towards your needs. Yeah.
Do any of these documents have to be registered with the city or the state?
No, none. The only thing that gets filed is if you pass away and you need a probate, your will gets filed, the original will gets filed. But a trust, silent, powers of attorney are silent. You should have powers of attorney on with your doctor or the banks when you have those created. But again, nothing gets filed with the state.
How long are you gonna, if we call your telephone number and to listen to this, how long are you gonna have that available?
Probably quite significant time. When I go to the legal seminars, I go to a solo and small firm conference. They're constantly telling me, start videotaping yourself and put it on your website. People want to see this. The young people typically want to see it. So we're going to have this. This will be our initial thing that we hope will be on our website soon. And then after that, I don't know if I'm going to get a YouTube channel or not. We'll have to talk about that.
Any more questions?
Anything else? All right.
Because the easier you make it for us to understand what you're telling us, it's to your advantage because we would recommend you.
Correct.
That's very important.
We have a worksheet over here we can hand you that has a 10% off if you come and see us, but it's a worksheet that allows you to fill it out, who you are, who do you want to do things, who's receiving everything. And we can draft the will package or the trust package off of that. So when you come in, you're kind of one step ahead. So that's over here in the counter. All right, and at our table. All right,
Thank you, guys.
yeah, nice to meet you all.
Thank you.
guys.